In this final selection of vodcasts, we're going to be dealing with a really important topic for business, that of the tort of negligence. So our first step is to understand, well, where does this kind of action fit in? What is it? What is negligence? And then how do we show it? So why don't we get into that right away? What we're going to be doing in our time together is to concentrate on this idea of how we show negligence under law to understand what we might need to do in business to overcome any problems we might have in the area. So to understand negligence, and we'll definitely know we'll come back to this a number of times, we need to understand how we show whether someone is liable for negligence or not. And there are 3 steps followed by the questions around a defence. So this will determine how liable or the level of liability that you hold. And you need to do these steps in order. And we'll go into that into more detail. But the first step is that we must owe a duty of care. The second step is if we owe that duty of care, we must breach the duty. Not only must there be a breach of a duty of care that we owe, that breach must actually cause the harm to the plaintiff. Okay, so a couple of things to wrap our head around. The plaintiff is the person who is bringing the action. So at first instance, they're going to be the person who is alleging that they were harmed by the action of the other person. The defendant, right, they'll be defending the action, and they'll be the person who it's alleged has caused the harm. Okay. Now again, this isn't shown yet because it's in terms of factually, we don't know did they really cause the harm legally until the action's over. So while it's ongoing, I'm using this word alleged. Allegedly causing the harm, etc. So the plaintiff is the person who has been hurt. The defendant is the action that we're looking to judge. So the defendants must owe the plaintiff a duty of care. They must have breached that duty of care, and that breach must have caused the harm to the plaintiff. Even once we finish that, even once we've gone through those 3 steps, then the defendant can ask, actually, did the plaintiff voluntarily assume the risk? They say, okay, so did the plaintiff actually know about this risk and take it anyway? Or actually, you can run both these defences, but you would also ask, did the plaintiff contribute to the negligence? So were they partly to blame, right? Or partly to blame? And it's only once we've done those 4 steps that we can know the level of liability that a defendant will have. We're also at the end of the lecture going to discuss this area of vicarious liability, and I'll talk about that more when we get to it. Our first concentration is around the tort of negligence. Negligence needs to be positioned in terms of the general law. So when we have some conduct or some action or omission, or even if we say something, okay, and that causes harm to someone else, where it's not justified or excused by law, then there are legal, right, really important for us in business law and ethics, legal consequences. Those legal consequences vary with the kind of action or omission or you saying something. So there can be criminal liability if you assault someone, right? There's criminal liability. There's tortious liability. There's contractual liability that we've dealt with in terms of contract already, right? Remember, our act or omission according to the contract can lead to liability. We have statutory liability, say the consumer protection that we've already done creates liability based upon your acts or omissions, and vicarious liability, which we're going to come to at the end of the lecture. One of the liabilities that can arise from your conduct is a tortious liability. A tortious liability, or a tort, is where we have a civil wrong, right? So it's not criminal. Now, note some actions like hitting someone. So if you hit someone, that can be both a tort and a crime. Okay, so one action can have more than one legal liability. But if we have an act that causes harm to someone, then the person might be able to commence a tortious action against us. Generally, tort law comes from case law. Okay, so it has been developed over time by the courts, but it is now clearly in some areas like negligence supplemented, and we know supplemented probably isn't the right word, it's been condensed and surpassed by legislation in some areas. As we go through, what you'll see is that we now have this mix of case law and statute in order to understand how we apply these tortious actions, particularly around negligence, in our jurisdiction. You'll be noticing that so far we've been using this idea of tortious liability as opposed to negligence. That's because negligence is a subset of the total kinds of tortious liability. So here we have three that are outlined for us to think about. So all of these are called torts. We have one which is negligence, the one we're going to concentrate on, and that's a breach of a duty to take reasonable care. Okay, so if you're negligent legally, you haven't taken reasonable care when you should have. Okay, so you had a duty to take reasonable care and then you didn't. You breached that duty to take reasonable care. Another area that we know a tortious liability arises is trespass, right? Which is where you're interfering with people or property. You particularly think about it as property trespass. And we also have the area of defamation. Okay, so we're not going to deal with all of these areas, but we need to understand that negligence is just one area, one subset of torts. In fact, negligence is the most common tort, and it occurs where someone carelessly causes harm to another person. We do have the civil liability reforms in the Civil Liability Act, which take up and supersede or at least condense the case law rules to date to make them clearer for us and limit some of this liability. So what we end up with in this area is a mix of traditional case law and the Civil Liability Act in Queensland. So we've got to be very careful that we're actually, if we're going to look for the particular piece of legislation, that we're looking in the right jurisdiction, that we're getting the Queensland Act. And finally, just to reiterate, that overall, over the entire area of negligence, we need to go through 4 steps. The first 3 will show that someone is negligent. You must owe a duty of care. You must breach that duty of care. And that breach must actually cause the harm to the defendant. Once you've shown that, must cause the harm to the plaintiff. Once you've shown that, you've actually shown that the defendant is liable for negligence. However, then the defendant can argue that the plaintiff voluntarily assumed the risk. And we'll learn that if they do voluntarily assume the risk, then actually the defendant won't be liable anymore, even though they would have been, because the plaintiff actually knew about the risk and took it anyway. Then the defendant won't be liable. And we'll also got to deal with the defense of contributory negligence, which is where the defendant, right, the person who's alleged to have caused the harm, can show that the plaintiff or the person who was harmed actually caused some of the harm themselves. They were liable as well. And so we get this kind of joint liability for the harm that's actually been caused. So that's an overview of it. in the next series, we're going to get into this idea of a duty of care. When do we actually have a duty of care? When can negligence possibly arise?